Good morning, good morning, everybody. My name is James Kidd. I'm a partner in our employment team. I'm actually your chair today, and so I'll hopefully act as the person that asks your questions easily and keeps our speakers on message and to time. So we're going to be here with you this morning for about 45 minutes. I'm going to let Neil and Ben introduce themselves to you in a moment. As the slide says, recording available. Please use the Q&A box to answer questions. Nobody else can see your question. There are no stupid questions. At the end, there will be a pop-up, which is a feedback request, which will come up in your browser. Please do complete that. We really, really appreciate the feedback. And there will be a couple of questions there about what it's going to be like for the future and attending events and things like that. So we really hope you do that. I'm going to now go into my American voiceover bit and see if this works. So, has your business been infected by COVID-19? If so, have you got business interruption insurance? I'll stop now because it's probably bad. But hang on, go back. So what Ben's going to be talking about is business interruption insurance, but probably not with the American accent, or at least my American accent, and actually some legal developments on that and whether it's going to be available or not. Neil, if his internet connection works throughout, which fingers crossed it will, is going to be explaining what D&O insurance was. And when we did the run through, I have to say I learned a lot about D&O insurance. So we'll come to that in a bit. And then do ask some questions. If we get time, we'll do the questions as we go. If not, if we have time at the end, we'll do it. And if not, we will follow up. So without further ado, over to Ben. Are you going to do the American accent?
It's better for everyone if I steer clear, quite honestly. So I'll stick with my slightly northern version. Thanks, James. Good morning, everyone. So as James said, I'm Ben Hardiman. I'm a partner in the insurance service line of Mills Reeve, and I work out of our Manchester office. I've spent a lot of time during the pandemic dealing with insurance issues and potential claims arising out of business interruption, or otherwise known as BI. And so today I just want to give you some insight into the issues I've seen, just to provide an overview of what BI insurance is. I'll then talk to you about a test case, which is a fairly landmark event brought by the Financial Conduct Authority. And then I'm going to conclude with some developments following a further case, which was reported just over a week ago. To the uninitiated, what is business interruption? Why have it? What's it cover? And what extensions are potentially relevant? BI isn't a compulsory insurance in the UK. It can be sold as a standalone policy, but it's commonly sold as an optional extra within a package of cover. It's almost like a pick and mix for events or risks which might impact on a business. So things like public and employers' liability, damage to property and its contents, professional liability, which is something Neil will come on to discuss in a minute. But although optional, the importance of BI can be seen in the value it provides. It's been estimated that insurers pay out approximately £22 million worth of BI cover to companies in the UK every single day of the year. Now, a property policy will generally provide cover to repair the damage to property caused by a major catastrophe, so a fire or a flood perhaps. What it doesn't cover is the loss caused by the interruption to the business by that event. So the consequential loss of revenue and the profit that is lost. And that's where the BI cover is necessary, where it kicks in. And what it provides cover for is the fixed costs of the business, such as rent and wages, the net profit of the business likely to be lost as a result of the event. And finally, it will also often cover the increased costs of running the business following the catastrophic event. So for example, the cost of renting alternative premises if yours is burnt down. And finally, to the scope of cover, and this is really the issue that has arisen and why the test case has come into play, because BI cover is generally predicated on the basis that there's been material damage to the insured property. So there must have been the fire or the flood for the BI cover to kick in. However, BI policies have evolved, and many insurers now provide extensions to provide cover for events which don't require damage. So the relevant ones for today's purposes and the things that have come to the fore as a consequence of the pandemic is cover for where a visitor is prevented from accessing the business premises or where interruption to the business is caused by a disease in the vicinity. And that is what the FCA test case is all about. So many businesses suffered financial losses as a consequence of COVID-19. Some turned to their insurers to make claims for cover via the BI policies that they hold. Now, the vast majority of policies sold to businesses in the UK do not provide cover for COVID-19 or the effects of the pandemic. But it transpired that there was a cohort of policies where the potential for dispute arose over whether cover did exist. And as a result, in May 2020, the Financial Conduct Authority, the FCA, which is the regulator of financial services firms, announced its intention to obtain court declarations which were intended to resolve the contractual uncertainty around those claims and around those policies. And the FCA's intention really was to step into the shoes of businesses and make the arguments for them. And that would avoid thousands, potentially hundreds of thousands of very similar claims clogging up the courts and the Financial Ombudsman Service, which is the service which resolves complaints by small businesses against financial firms such as insurers. So the FCA worked with insurers to come up with a sample set of 21 policy wordings. 8 insurers were represented, and 2 action groups, the Hospitality Action Group and the Hiscox Action Group, were given permission to join to advance arguments on behalf of their cohort of clients. Now, as the slide shows, while only 8 insurers were involved in the litigation, the decision has actually fairly far-reaching consequences. So there are potentially 700 policies out there in the market written by around 60 insurers who are potentially affected by this decision. And in terms of policyholder numbers, the litigation is said to potentially affect 370,000 businesses in the UK.
Ben, just to jump in, is that 370,000 financial services businesses, or is it 370,000 businesses?
That's any type of business. So it ranges from restaurants to manufacturing firms, some financial services firms, but generally that's a difficult claim to make, it transpires, but it can be any type of business. Now, the High Court reached a slightly mixed decision in September 2020. It found largely in favour of the FCA and therefore for businesses, but some elements of its decision went in insurers' favour. So the insurers appealed, but also the FCA appealed itself about certain aspects of the High Court's decision. Now, due to the importance of this case, the case bypassed the Court of Appeal, which is the normal route, and it went straight up to the Court of Appeal. They heard the case in late November, and the decision was, Supreme Court, and handed down the decision in January 2021. So we've managed to get from a claim starting through to completion in just over 9 months, which is absolutely unprecedented. It shows the level of cooperation that has occurred between the FCA, the courts, and the insurers together. The decision is binding on the insurers as a test case, and its principles will be considered by other insurers whose wordings are broadly similar. And I just want to give you a taster of the 3 types of clause which were considered, so that potentially you can consider whether you may have any benefits. So first, to the disease clauses. They will often be found in a section of your policy which covers other types of that non-damage risk I mentioned earlier. So, for example, business interruption caused by murder, suicide, disease, and vermin at the premises is often the heading it falls within. And a typical clause is as on the screen. So, cover for BI losses resulting from the occurrence of an infectious or notifiable disease within a specified radius of the property. Now, that will often be a mile. It can be up to 25 miles from the premises, and that will be important in terms of the ability to prove a loss. Now, the Supreme Court has decided that the disease clauses are triggered by the occurrence of an illness sustained by any person, resulting from a human infectious or contagious disease at a particular time and place within the radius specified. Now that seems fairly straightforward. It seems pretty obvious. It is what the clause says. But what insurers had argued is that this type of policy extension is intended to provide cover for localized events. It's not intended to cover the consequences of a global pandemic or the government and the public's response to it, i.e. the stay-at-home response. So insurers argued that whilst there may have been cases of COVID within the radius, as the policy provides for, there have been many more cases outside of it. And it's that wider aspect that insurers said this doesn't provide cover. Now, the Supreme Court has dismissed that argument because it would ultimately very severely limit the extent of cover available. It would be virtually impossible for a business to show that its losses only resulted from those localized cases. So in the main, those policies do respond.
Ben, how is a business able to ascertain whether there has been an outbreak within the specified radius?
The question of proof hasn't been considered by the Supreme Court. What the FCA has done is to undertake a consultation. There's a document that they've released which is available on their website, which sets out the steps that policyholders or businesses need to take to prove a loss. That's quite a helpful document in terms of showing the sorts of data that businesses can rely on. But ultimately, where we are likely to get to is the FCA has said insurers are expected to report where they accept claims. So if, for example, there is a claim accepted on a high street in Manchester, other businesses in that vicinity will be able to work out that claims have been accepted, which helps in the proof. So moving on to the second type I mentioned earlier, the prevention of access. And again, the typical wording is on the screen. They generally provide cover for interruption losses resulting from public authority intervention. So that may be the police, it might be the local council, which prevents access or use of the business which is due to an emergency likely to endanger life or property. Now, the High Court had taken a restrictive view of these clauses, and its decision largely fell in favour of insurers. Not all of the High Court's decisions on this were appealed. So Ecclesiastical and Zurich are two insurers who have a denial of access clause, and their policies were found not to provide cover, and that decision hasn't been appealed. So there's no change there, they don't provide cover. On the decisions which were appealed, which affect the other insurers, the Supreme Court has overturned the High Court's decision, and there's two key reasons for that, and both fall heavily in favour of businesses. They broaden the scope of cover that the High Court's decision would have created. Firstly, the nature of the intervention necessary. The High Court said that only an instruction or restriction with full force of law is sufficient to trigger the clause. The Supreme Court said that is wrong. An instruction is sufficient to amount to a restriction if compliance is expected or required. Force of law is unnecessary. So when the Prime Minister instructed businesses like bars and restaurants to close on the 20th of March this time last year, that may not have been legally enforceable at the time, but everyone knew what was meant by it. And the reason it's important is because it extends the period over which losses can be claimed. Secondly, the nature of the closure is important. Again, the High Court was strict. Only a complete closure of the entire business is sufficient. This, the Supreme Court said, was wrong. The requirement for there to be a denial of access can be satisfied if a business is unable to use a discrete part either of its premises or of its business activities. So just take a golf club with a bar as by way of an example. While the course was allowed to stay open at the outset, the bar was not. So there was an inability to use a part of the business and the premises. Now, it might be a discrete part, but it's important for the purposes of generating revenue for that business. And that's exactly the purpose of a BI policy. I've mentioned hybrid policies on the screen. They're exactly what they say on the tin, so I'm not going to spend any time with those. They combine the main elements of the disease and the prevention of access clauses. And for those, we need to apply a combined analysis of the two types of clause I've already discussed. So overall, the Supreme Court's decision was far more generous to businesses than the High Court had been. It makes it easier for businesses to trigger cover, and in some areas, it's going to give them the chance to benefit from more cover over a longer period, even where they kept the business open. One thing that's important to note is that the decision doesn't decide how much is payable. It gives the principal to consider whether or not the policy is triggered. Insurers are expected to deal with the quantification of claims in the normal way. Now, the judgment runs to about 115 pages. So what I'm not able to cover in the time today is the extensive argument about causation and a case from 2010, which had found in insurers' favour on this, called Orient Express. Now, just to give you an overview, for any claim of this nature, causation must be established. And insurers argued, as I indicated earlier, that businesses would have suffered the same or substantially similar losses in any event because of the wider effects of the pandemic. Now, causation is a talk in itself, but the headline summary is that the Supreme Court found overwhelmingly in the FCA's favour on this issue. It dismissed insurers' arguments, and it found that businesses can establish the necessary causal link between the insured events, so the disease, and the loss that they suffered. And then very quickly and finally, and it's quite important because I've been asked a number of times over the last few months about a type of wording known as a specified disease clause. And this was considered in a case called Rockcliffe Hall and Travellers. It is not something that fell within the scope of the consideration of the Supreme Court. These sort of policies, the insurer defines all of the diseases which it is prepared to cover. So it's quite different to the unspecified version in the Supreme Court wordings. Now, you won't be surprised to hear, I've never seen one where the words COVID-19 were included. And what Rockcliffe Hall sought to do is to argue that the word plague in one such specified list, which was insured by Travellers, would encompass COVID-19 on the basis that it's widely accepted that plague is a general term for an infectious disease with a high mortality rate. So COVID-19 perhaps. Now, the court comprehensively dismissed this argument. It's not open for a business to argue that specific words in a defined list should be open to further interpretation. So you can't broaden the word plague to encompass something else. So if you are a business with a specified list wording, I'm afraid it's very likely that you do not have cover for COVID-19. Where you do, you may have an opportunity is via the two clauses I spoke about earlier. As I say, it's been a bit of a whistle-stop tour. So if you are interested in any of these topics, there's a link on the screen that you can get to via the QR code, where you'll find a more in-depth webinar about the decision and a couple of articles about the two cases. What I'll do now is hand over to Neil to discuss directors and officers insurers, unless, of course, James has any questions.
You prompted that very well, didn't you? Very good. So two questions. Just, does business interruption insurance apply when a business is closed as a result of a COVID outbreak on site?
So the test case didn't consider what's known as an at the premises wording. So this is the radius point I mentioned earlier. It's considered 1 mile, 25 miles. I think the principles apply, the same principles apply. I think the challenge for a business who has that wording is how you prove it. How do you show that there was an occurrence of that disease on the premises? It's easier if it's within a mile, for example. On the premises is far harder to establish. Okay, thank you. And there's just a question less for you, more for the back office team about we're giving you a QR code to a LinkedIn point. Is there a way of accessing the stuff rather than through LinkedIn? I won't name the person who's raised that, but we'll look into that and see if we can come back to you on different links, which we'll send out later. Brand new question for you, Neil, just hold on for a second more. Specified disease clauses seem useless. What is COVID-19? What if COVID-19 was called Plague 19? I suppose they're not useless if you have an occurrence of the disease which actually is specified. So often they'll include chickenpox, they'll include cholera, and a whole host of weird and wonderful items in between. The idea of these clauses is that it sets out what the insurer is prepared to insure, and the whole principle of the test case from the insurer's perspective is they didn't underwrite a risk which included effects as broad as a pandemic. So in some ways it provides a bit more certainty.
Yeah, but not to the insured's benefit.
Perhaps not.
Yeah. So takeaways are, if you do have business interruption insurance, have a look at that. There might be some good things there. If you have a specified disease, that might not be such good news. Neil, who's been champing at the bit, eager to tell us all about directors and officers insurance. Off you go.
Hi there. Thank you very much, James. My name is Neil Howes, and I'm a partner in Mills Reeve's insurance disputes team, and I'm based out of our Leeds office. And actually, part of my practice is defending directors and officers when claims are made against them. And I remember shortly before lockdown one, about this time last year, I did a session to a whole host of in-house lawyers from across the country, and we started to talk about D&O insurance, and we did a bit of a straw poll, and there were quite a significant number of the lawyers in the room who weren't sure whether their business actually had D&O cover, and actually, more importantly, a significant number who weren't really clear what it was or how it worked. So we thought we'd focus on a couple of those issues today, and also to have a look at what impact COVID might have on D&O claims. The first point to say is that directors and officers insurance, or D&O, covers a company's directors and its key personnel, and usually the company itself, against claims for damages for wrongful acts. So you'll see on the screen that actually D&O cover potentially covers you against a whole host of claims that you wouldn't otherwise be insured for. So everything from shareholder claims, regulatory actions, data breaches, director misfeasance, all the way through to things like defamation claims, and at the top end of the scale, corporate manslaughter. It often forms part of a kind of wider management suite of policies, if you like, which might include things like employment practices cover and pension trustee liability cover as well. It is probably, D&O, the most useful form of insurance you never knew that your company had. So how does it work? Next slide, please, Ben. So when you talk to brokers and other people in the insurance industry about D&O cover, they might well start to talk about side A, side B, and side C, which starts to get a little confusing. So what does that all mean? It basically means various parts of the policy. So side A of the policy is basically personal cover for directors and other key personnel known as insured persons. Okay, there are certain circumstances in which companies can indemnify directors in law when a claim is made against a director, but of course the company might be financially unable to do so, or maybe unwilling to do so. And so side A there is to protect and provide cover for the individual. Definition of insured persons is normally quite wide, and so it probably also covers in-house counsel as well. James.
Yeah, thank you. You saw me waving my hand.
I did, yeah.
Question, that is it not a fact that articles and memoranda have to allow indemnification of directors? I'm not a corporate lawyer, but I think that's an option rather than a mandatory, isn't that? Is that right?
I think it's an option, and of course it still wouldn't help if the company is financially unable to indemnify the director.
Yeah. Okay. Tom.
So side B is basically there to indemnify the company when they have kind of supported the director financially and paid any damages and costs the director might be liable to pay. It is, if you like, just the flip side of side A. Okay. Side C is something slightly different. It is potentially a kind of an optional cover, but it's corporate liability cover, and it normally comes as part of your D&O package. That's really valuable, that side C cover, because it is the part of the policy that covers the company itself when a claim is made against it for a wrongful act, and not just if a claim is made against a director personally. So it's a very, very valuable type of cover to have. And I would recommend that you have a check of your D&O policy just to make sure that you've got corporate liability cover as well. So how does it work? Next slide, please, Ben. So most D&O policies, they have a kind of standard cover, and then there are additional optional extra covers that you can take out if you want to, normally for an additional premium. But your standard cover basically covers a director or the company for any financial loss which results from a claim and which arises out of a wrongful act. So all of those three things need to be present in order for the policy cover to kick in. So financial losses you'd expect, that would normally include damages, costs that the director might be liable to pay, defence legal costs, things like civil fines as well. A claim has normally has a very broad definition of the policy, would include a civil claim for damages, but it also would normally cover various regulatory actions also. And wrongful act, again, generally speaking, very broad definition, covers everything from breach of duty, breach of trust, neglect, error, misfeasance, even things like defamation and wrongful trading. Now, your additional covers, as I've said, are kind of optional extras that you can kind of buy if you want to, buy if you don't, but actually additional covers can be really broad. So you might have additional cover for emergency legal costs if you need them. You might have additional cover for things like PR costs. If a claim is made against a director or a company and that has a negative impact on the company's public reputation, then there may well be cover for PR costs to help with that. I even saw one the other day where one of the additional covers was kidnap or ransom if one of the directors or a member of their family was kidnapped and insurers needed to pay out. Hopefully, none of you will need to call on that one. Next slide, please, Ben. Now, like every insurance policy, D&O policies are subject to various exclusions, okay? Certain things that simply won't be covered no matter what. So the first and most obvious example are claims which would be covered by other policies. So claims that would be covered by your professional indemnity policy or your employer's liability policy, things like that won't come under your D&O. Also, prior claims and circumstances, in other words, claims that have already been made or circumstances that might give rise to a claim that have taken place before the start date of the policy. Most policies will also include a fraud or a dishonesty exclusion, okay? So where the director or the company has acted dishonestly or financially benefited from their own breach. That said, even where those exclusions are in, the director is normally still entitled to defence costs, at least for part of the proceedings. Some policies will have what's called an insured versus insured exclusion. That means it won't cover any claims that the company makes against one of its own directors or claims that are made against directors by other directors. So insured versus insured actions. And your corporate liability section of the policy, that won't cover you for breach of contract claims. So if you get into a contractual dispute with one of your suppliers, it won't cover you for any damages you have to pay out. But, and here's the thing that people often miss, your corporate legal liability policy probably does cover you for legal defence costs if you're being sued for breach of contract. So that's all well worth bearing in mind. So just, oh, sorry, James.
This hand waving is working well, isn't it?
Indeed, yeah.
Just a question about how do we recommend a limit on the indemnity, presumably for the indemnity given by the company or the indemnity for D&O? I wasn't quite sure about the question, but is that a broker question?
That is one to discuss with your brokers. It very much depends on the size of your business and its business activities. I mean, a typical D&O policy will have anywhere in the region of several £100,000 worth of cover to several £1 million worth of cover, depending on the company.
Okay. Sure. Ben, I'm going to ask you a question about Sean. Can you look in the chat? But I'll come to that later. There's a question that says, I'm a legal director at a large care provider. This is for you, Neil. What about abuse exclusions under the D&O policy? We need abuse cover, but I've seen this limited even further over the past few years. Any views on that?
Yeah, I mean, again, it all comes down to the wording of your policy. What I'd also do is check your D&O, because actually abuse can, in certain circumstances, be covered under that. The other policy to check in terms of abuse claims is your employer's liability policy, your EPL policy.
Okay. And I'll come to that. I'll come to you on that other one when we've finished on Neil. Okay.
No problem at all. So next slide, please, Ben. So just putting this all together and seeing how it works in practice. This is a case that I dealt with a few years ago. Senior board director of a well-known national house builder alleged to have misused the company's new build discount scheme to sell multiple houses to family and friends at significant undervalues. Company says that cost the company several £1 million, sacks him, gets a freezing injunction over his assets. Court proceedings are instigated. The director denied liability. He basically said it was a witch hunt, it was a stitch up. He said as far as he was concerned, he'd complied fully with the discount scheme rules, and he believed that actually he was acting in exactly the same way as various other directors on the board as well. So in that situation, the D&O policy will generally kick in. The first point to mention is that assuming there's no insured v insured exclusion, the director will be looking for the D&O to step in and help to fund his defence costs, which are going to be substantial. If he's found guilty of misfeasance, of misusing that company scheme, then potentially the policy also covers him for any damages and legal costs that he has to pay out. The one thing that I would say is that there was a kind of sniff of dishonesty in this case in terms of some of the allegations. And so if that dishonesty is proven, then the director won't be entitled to cover. And so that will be something that insurers have got an eye on as they can continue to manage the litigation as it goes through.
So does that mean the director gets his legal costs paid, but any award made against him, he or she has to fund themselves at that point?
That is potentially right. And if a finding of dishonesty is ultimately made against him, he may well have to pay back the legal costs that have been paid out by the insurer. What often happens in practice is actually if matters are resolved, then probably there is a way to approach it so that the director stays with cover. So before we finish, I just wanted to talk very briefly about the impact of COVID on D&O claims. So at the start of lockdown 1 and early on in the pandemic, there were quite a few articles flying around in the press about this being ripe for a kind of tsunami of claims against companies and their directors. I don't think we've seen a tsunami by any stretch of the imagination. I always felt that was a bit overpitched. I think, though, we are going to see situations where certain elements of D&O claims rise over the next few years. I've mentioned on the slide there various claims that might be made against company directors as a result or connected with COVID. I don't have time to touch on all of them, so I thought I'd just touch on 2 or 3. The first one where I think we may see claims against directors rise is in claims by shareholders and investors as a result of, particularly in public listed companies, where incorrect financial information has been put out to the market, which has had an impressive impact on the share price, but later turns out not to be correct. We've seen a couple of those cases already over in the US, one against a cruise ship company whose share price went through the roof because they said all their cruises were COVID safe when they turned out to be anything but, and also a pharmaceutical company who very early on in lockdown 1 said it's all right because we've found a vaccine. And again, that turned out to be rather optimistic. I think we're also going to see a rise in claims by regulators. So you can foresee situations where the health and safety executive starts to get involved if employers have acted so badly that they've been putting their employees' health at risk. We've got everybody working from home, of course, at the moment in a lot of sectors. We are already starting to see a rise in data breach claims, which generally are covered under your D&O corporate liability policy. But I think we're also going to start to see action by the Information Commissioner in certain circumstances if companies haven't taken proper steps to prevent data breaches during lockdowns. The longer term impact of COVID, I think, is going to be economic, and I think it's a sad fact of reality that over the next year or so, we will start to see businesses unfortunately going to the wall. It's at that point that administrators, liquidators start to get involved, and they will obviously be going through the company's affairs. And actually, we will start to see a rise, I am sure, in claims by liquidators and administrators against directors for misfeasance, fraudulent trading, and also potentially for wrongful trading, although actually the wrongful trading rules have been suspended for quite a lot of the lockdown period. I know, talking to some of my insolvency colleagues, that they fear, though, that that may have lulled some directors into a bit of a false sense of security when it comes to kind of honouring their duties. And finally, I've been asked quite a few times as to whether we are going to see a rise in claims against directors for mishandling of COVID, bearing in mind that a director's duties include a duty to kind of act with reasonable care and skill. You might see situations where minority shareholders think that that crisis has been handled badly, start to sue directors. You may have companies who sack their directors for not handling COVID well and then potentially bring claims against them. I think, in all honesty, we may see some of those claims, but I don't think that many of them are really going to be successful for two reasons. Firstly, because actually for a minority shareholder to bring a claim against a director is actually quite a tough route to go down. The court's permission is required, and the test for permission is rather high. And secondly, I think the courts will recognise that the last 12 months or so have been absolutely extraordinary. And I think they will be very loath to criticise directors dealing with an entirely new set of unprecedented circumstances. So I think we're only going to see those types of claims be successful when the directors have been guilty of very serious wrongdoing, potentially those cases where a director has done things simply for their own benefit and not for the benefit of the company. So D&O, really useful type of insurance to have. You probably have it tucked away in a cabinet somewhere, but it probably provides you with cover for more things than you think. So I would just suggest when you get back to the office, do go into the back of the filing cabinet, see whether you've got it, and check what cover it gives you.
Brilliant. Thank you, Neil. Right, let's do quick fire. I know the answer to this. Do you think the cost of D&O policies is likely to rise significantly?
I think the cost of D&O will rise. I think it's a hardening market at the moment. I think there will also be some exclusions which become more common in the market. So talking to various underwriters over the last couple of months, we're already starting to see a rise sometimes of insolvency exclusions. In other words, policies that won't cover directors if they're sued by liquidators or administrators. So I think we will see some changes. It is a hardening market, but I don't expect premiums to go through the roof, because the flip side is I think there will be more demand than ever before for D&O insurance.
Okay. You know your case about the dodgy director selling the houses on the side to family and friends?
Indeed.
The question is, how is that case regarding the director not an insured versus insured case to exclude cover?
It depends on whether the policy has an insured versus insured exclusion. So those type of exclusions are becoming far less common as time goes on. Okay. So in that case, for example, let's assume that there's no insured versus insured exclusion, at which point the cover kicks in. If there is an exclusion, yeah, the director's on his own. But again, a good opportunity to go back to your D&O policy and say, well, actually, do we want this exclusion in? And if not, can we talk to our brokers about getting it removed potentially on next renewal?
Okay, live feedback. Somebody says we're talking to our brokers about renewal and rates are going up significantly. There you go. This is the law in action. This very specific one. Would you expect a D&O policy to cover directors when acting for a company which is the trustee of life insurance policy, i.e. death in service, about making decisions about distributing, not easy for me to say, funds? So will there be insurance cover? I'm going to give the money to this person or this person in that respect for death in service. So if they get that wrong,
yeah, potentially it could. I mean, it would depend on the wording of the policy and the circumstances of the claim. But yeah, potentially the D&O cover might apply there. Yeah.
Okay. I need to read. Do you want to just read the very long question that's just come in, and I'll go back to Ben on this one. So we're starting to see some signs of policyholders bringing claims against their brokers for not having arranged the broadest disease cover available. This is back to specified diseases in the market for their client, i.e. not specified diseases only, but an unrestricted cover. How exposed do you think brokers may be to such allegations?
Yeah, I understand that notifications are being made by brokers in respect of complaints, generally speaking, or grumbles from clients at this stage. But claims are starting to come through. I personally think that they're very difficult claims for businesses to bring. If you look at the facets of what a business has to prove to establish a claim against a broker, so they had a duty to provide this advice, that the COVID-19 and the pandemic was foreseeable, and then that advice, assuming it was negligent, has caused the loss. I think all of those factors make it a very difficult claim to bring, but I expect there will be claims. Okay,
thank you, Ben. More feedback that insurers are increasing premiums by 100% and doubling excesses. Wow, that's I suppose you could say they've got to recover the payouts.
I think though, genuinely, that things will start to even themselves out over the next year. I think the market is braced for a rise in D&O claims, but I don't think we're going to see the tsunami that's expected. So I can understand, and I understand that premiums are going up significantly. I do wonder whether over the next couple of years that might calm down a little bit.
Okay. I think there is a quote from a policy about exclusion. I wasn't sure I followed that. Did you?
I wasn't sure that I followed it either, unfortunately.
Okay. So if you want to put a clarification in there to the person who raised that, that would be great. And we can always follow up later. All right. I'm going to call this at 10:44 and to say thank you very much to Ben and to Neil. Really, really insightful, and appreciate those pearls of wisdom. Do check your D&O policies, do check your business interruption insurance. So there will be a recording available afterwards. Once you leave here, there will be a pop-up. Please do give us some feedback. That would be fantastic. We really appreciate that. It's very helpful for us in planning these in the future. Have a great day, everyone. Take care and stay safe. Take care. Bye-bye.